McCutcheon.
You keep saying there's no evidence of this kind of coordination resulting in a quid pro quo or the appearance thereof, but the whole campaign finance board is law is based on just such an evidence. In the early 1970s, that's what led to all of this congressional action. The dairy industry channeled millions of dollars to President Nixon through the Republican Party and its committees. The industry landed a $100 million subsidy from President Nixon in return. Was there a quid pro quo? There certainly was an appearance of quid pro quo. That's what started the entire campaign finance reform legislation. The threat hasn't diminished. One impetus behind the Bipartisan Campaign Reform Act, the more recent one, was to address how donors were funneling soft money to national parties that those parties would then use to benefit federal candidates, to national parties. There was ample evidence, and I'm citing from our own case law on this, about how parties were willing intermediaries. The evidence in McConnell showed that this circumvention was effective. Donations from the tobacco industry to Republicans scuttled tobacco legislation, just as contributions from trial lawyers to Democrats stopped tort reforms. And in Colorado, too, this court cited the tallying scheme used by the DNC. That was an informal agreement between the DNC and candidates, in which candidates encouraged donors to give to that party with the tacit understanding that the party would funnel that contribution back to the candidate through coordinated expenditures. I don't understand how you can say there's a lack of evidence. It's replete in all of our cases and in the history. And if there's not direct evidence, it's because our umbrella is working. Your party said to us that we did not have to worry about independent expenditures at a limit because we had laws that stopped coordinated contributions. So what you told us was the prophylactic that was enough for us to rule in favor of unlimited expenditures. You now want to take that umbrella completely away. That's your point.
So, Your Honor, there's a lot in there, and to unpack it a little bit, I think where I'd start is the FEC actually had an expert below and built the record, and the FEC's own expert conceded that none of the examples that he had or any of the other historical examples actually involved coordinated party spending. So there's no example of coordinated party spending ever being used.
Because it hasn't happened. We've been prohibiting it since Buckley.
And, Your Honor, that is my second point. We actually have 28 states in this country that impose no limits on a party's ability to coordinate with its candidates, none. We don't have any example from those 28 states. We have the 2014 amendment, which tripled the size of the base limit for certain types of contributions, completely excused it from coordinated party expenditures. We have absolutely zero examples of coordinated party spending in that context being used for quid pro quo bribery. We also have existing law that allows $44,000 contributions to us, which can be coordinated in amounts ranging from $60,000 to $4 million, depending on the race. The number of examples of the type of quid pro quo conduit bribery they're concerned about in that context, zero as well.
Thank you, counsel. Justice Thomas?